Welcome to Week 4, Drafting Rulings Part 2, Discussing Statutory Law. During this week, you have evaluated your statutory law in relation to your draft ruling and gained a clear understanding of how your draft ruling, being the facts and issue from Week 3, has been incorporated into the ruling process in Week 4. You have further learned the importance of precedent and analogy and have gained further insight into legal reasoning and the elements that are applicable thereof. The following slides will help place more understanding to your learning for this week. The reading of Cartier, L.H. and Burke, T.F. 2016, Reason in Law, sets out the following 4 elements of legal reasoning to persuade us that the law ought to mean what the judge has decided. The well-reasoned judicial opinion will harmonize the following 4 basic building blocks present in every case. Step 1. The case facts established in the trial and preserved in the record of evidence produced at the trial. Step 2. The facts, events, and other conditions that we observe in the world, quite apart from the case at hand, which we call social background facts. Step 3. What the rule of law, that is, the official legal texts created by the state, say about the case. Step 4. Widely shared moral values and social principles. These 4 building blocks are the foundation of good legal reasoning. Judges need to take account of each of them in explaining their decisions. When judges reason well, their opinions harmonize or fit together these 4 elements. When they don't fit together the elements, their opinions become less persuasive. It is suggested in the reading that legal reasoning is at heart a kind of artistic practice, a harmonizing of elements akin to the harmonies constructed by a music composer. Precedent and analogy are 2 central and complementary forms of legal argument. What makes them characteristic of legal reasoning is the circumstances of decision-making in law. The greatest contrast is with the individual reasoning, where neither precedent nor analogy have the same significance. An individual may give weight to what she has done in the past, example, because she believes the decision was made under optimum conditions, or she should not or does not want to disappoint someone's expectations, or there are special reasons to treat the 2 situations identically. Similarly, the comparison of the problem at hand with another situation may help clarify one's thinking, but one's judgment on the other case is only relevant to the extent that it is correct. In an institutionalized system with many decision makers and a heterogeneous group of legal materials, there is a tension between decision making being relatively predictable for those to whom it will apply and the law being morally improved. In such a context, precedent and analogy help to shore up the predictability of decisions whilst leaving room for courts to improve the law. They do this in 2 different ways. Precedent are distinguishable and subject to overruling, while analogies provide non-conclusive reasons for reaching a particular outcome. The success of these compromises depends upon there being a fair measure of background agreement between decision makers over the important values served by law. Both measures would be too weak in the face of widespread and deep value disagreement. A range of mechanisms exist in the law that help maintain such a relative consensus. Legal education, the working environment, and the selection of candidates for the bench all tend to produce more convergence than is found in the general community. In addition, there is an internal feedback element. In deciding cases, courts are aware that the decisions can be distinguished as well as overruled, and that it is only their ruling that are binding on later courts. This gives them good reasons to press justifications that are based on values widely endorsed by their brethren. This week's learning outcome will form a valuable foundation for the weeks to follow. You are encouraged to read further on any additional readings if you can. including the readings required for this learning unit, to guide you in your evaluation on the applicable statutory law in relation to your ruling. You are further tasked to draft a mind map in relation to the use of precedent and analogy in legal reasoning, and further answer questions in terms of a case study. Join me for the next week as we draft rulings part 3 discussing case law and articles.